Started?
Yep, let's get started. Okay, welcome everybody. Really appreciate you coming in. My name is Joseph Barnett. You can call me Joey. I am a partner at our firm's Los Angeles office. I've been doing EB-5 for about 10 years now. And I am joined by my partner, Vivian, if you want to introduce yourself.
Hi everyone, I'm Vivian. I have known a lot of you here listed. I see your names. I know a lot of you. Thanks for coming to our webinar today. And we're gonna be discussing this new EB-5 policy on redeployment.
And you know, this is a Zoom. If you guys have questions, feel free to type in. For example, we've already got one question. Will this deck be shareable? The answer is yes, it will be shareable. Just let me know and we can send you a copy of it if you like it. And so what we're going to be talking about is USCIS's recent guidance, interpretive guidance, clarifying guidance about EB-5 redeployment, which has a huge impact in the EB-5 industry. And we're going to be getting into the nitty-gritty here, but we have to do a legal disclaimer. Of course, we're attorneys. This is not create an attorney-client relationship. This is just for informational purposes. If you have questions, you really do need to schedule a consultation, in particular because redeployment is so often a case-by-case basis on what works or not. And so, you know, please give us a call. We've been doing EB-5 for many years. You know, just a little bit more about our firm. We have offices throughout the United States. We've been doing EB-5 for decades and have filed thousands of I-526 petitions from individuals and investors from China, Vietnam, India, Canada, South Africa, Russia, all over the world. And so we are a full service firm. Just a little bit more about us. You know, we're considered one of the top practicing firms in EB-5 in the country. We're one of two immigration firms that have been ranked by Chambers US in Southern California as a Band 1 immigration law firm. And here's just a little bit about Vivian and I. And it is very, very wonderful to be here. So let's just dive right into it. This is what we're going to be talking about today. And, you know, redeployment has been around for quite some time. In the draft policy memo in August of 2015, USCIS talked about sustainment, which is the maintenance of your EB-5 capital investment over 2 years of conditional green card period. And they indicated there, without much guidance, that you must continue to deploy such repaid capital in activity for the remainder of your sustainment period. And that opened up a lot of questions. And then in 2017, in June, they put out, without notice, without comment, this guidance saying, you know, that you must redeploy money. And that led to a whole change of offering documents and has led to a lot of different complex issues involving EB-5. And then just last month, 3 years later, they updated their policy again. And there has been no stakeholder meeting scheduled to discuss this policy. And it is subject to change without notice. And that's one of the big issues of this policy, is that, you know, as a regulated group of stakeholders, we need to know how to identify and put together applications to comply with EB-5 rules. And as they change them and unfortunately apply it retroactively, that puts a lot of pressure on projects, on investors, and on their attorneys to make sure that what we do is right. And so there, you know, there are comments that are allowed through August 24th. You can submit comments to USCIS, and it'll be interesting to see what they do with those comments and if we will have new policy potentially because of those comments. And one thing that I wanted to just take a sort of 30,000-foot view on when it comes to EB-5 redeployment, before we get into the specifics here, is that to me, there are three separate but related areas of law that redeployment gets to. First, there is immigration law, compliance with USCIS, making sure that what a project does, what a new commercial enterprise does, complies with the regulation and allows investors to move forward and get their conditional green cards. And then later on, the removal of those green card conditions and a full permanent green card. That's what we're going to be talking mostly about today, is the immigration law. But on top of that, what we're asked about a lot by our clients relate to the two other areas of law. One, which I sort of consider it business corporate law, the management of the actual new commercial enterprise, what rights EB-5 investors have contractually to influence a redeployment option. Your relationship between yourself as an EB-5 investor and the manager of the company. That is all governed contractually. And then the third is the financial and securities aspect of redeployment. What disclosures need to be made? Our rescission rights need to be given. What type of due diligence must the new commercial enterprise engage in? And what investment risks must they consider when they are looking to do this redeployment? What fiduciary duties are they responsible to comply with? And I think a lot of that gets to, in my mind, with EB-5, it gets to liquidity. Investors want to be able to get their money back as soon as possible once they have met that sustainment period, which is the 2 years of conditional green card status. And so, what type of liquidity can be provided, if any, at this point, to be able to return that capital investment to investors at as early as possible. So Vivian, why don't you talk about redeployment in the EB-5 process and give just sort of a conceptual basis of, how does that money need to be at risk and sustained?
Sure. So let's look at redeployment and in the EB-5 process. How did redeployment even become a thing? And why do you need to redeploy your EB-5 capital in the first place? So what we have here is a flow chart that shows your EB-5 application process. We know that EB-5 regional center investments are usually structured as a 5-year loan or investment by the NC into the JCE. Why it's 5 years? Because if you look at the flow chart, originally or previously, the process takes approximately 5 years to complete. We filed the 526 application, and before it was like in average 1 year processing time, and then you get to go to the consular processing or visa interview to get your stamp, and then you land in the US and get your conditional green card. And 2 years after the conditional green card period is over, we file your 829 petitions, and once it's approved, you get the, oh, sorry, there's a typo. It should be 526 approval, the first one, not 829 approval. So after the conditional green card period is over, we file the 829 petition to remove the condition. And once it's approved, you get the 10-year permanent green card. So previously, when there were not so many EB-5 applications, the whole process from the investment to the time you get your permanent green card is approximately 5 years, give or take. But the problem is, in the past few years, the EB-5 program has become so popular, and there are so many investors, so many applications were filed, and there was a visa waiting line created for countries like China and Vietnam. That was the ultimate reason the redeployment requirement was created, or even being discussed right now. Because of the visa waiting line, the wait time for the conditional green card exceeds the term of the 5-year EB-5 loan. With that situation in mind, the USCIS says if a loan is repaid to the NCE after 5 years, but at that time, if the investors are still waiting, they're still not haven't met their 2-year conditional green card expiration date, the money must not sit in an account. It has to be reinvested or placed back at risk in order to sustain a full 2-year sustainment at risk period requirement. That's why for some investors, especially for people from China, where they have a huge backlog, visa backlog, they will have to face the problem for redeployment. Especially last year, the Department of State has announced that for Chinese investors who filed their 526 in 2019, the visa waiting line may be even over 15, 16 years. So for those people, they would definitely need to face the problem of redeployment. And when this EB5 capital should be redeployed, the USCIS rule says once the job creation requirement has been met and the investment is returned to the NCE, the NCE may redeploy the money within a reasonable period of time, now defined as 12 months. So based on this rule, if the investment capital is returned to NCE more than 12 months before the expiration date of your conditional green card, the NCE should redeploy your investment. In other words, if at the time the original project is completed and the capital is returned, your 526 is pending, or you're waiting for your priority date to become current, or your priority date is current, but you're waiting for your visa interview to be scheduled, or you're still in the first year of your conditional green card period, you will have to deal with the redeployment issue. And after the 2-year conditional green card expiration date, technically you can get your money back. There's no sustainment at risk requirement after that point. So Joey, can you talk about how redeployment should be carried out as in practice, and who should redeploy the money and who should look for the new project to redeploy the capital?
Yep. Thank you for that, Vivian. And I pulled up this EB5 project structure slide because I think it just sort of helps conceptually for people to understand. When you originally are doing and looking at an EB5 project, you're looking at the initial job creating entity. Redeployment here comes back when that job creating entity has created the jobs and now has repaid the loan back to the NCE. If the money is sold before that conditional 2-year period is completed, it can't go back to the investor, right? It can't, because then it's no longer at risk. It cannot just sit in that NCE bank account indefinitely. They're saying now you need to redeploy it within a reasonable amount of time. And so we have this further redeployment into an alternative investment to satisfy that at-risk requirement. And actually, there should be another arrow between the regional center and the box that I have redeployment option, because under this new policy guidance, that redeployment option must be within the existing regional center's geographic area. Either at the time of employment, or excuse me, at the time of filing, or you can expand the geographic boundaries prior to redeploying the money into that expanded area.
And
so
the amendment should be approved before you can use the new RC territory, right?
Correct.
According to the new rule.
Absolutely. And I just want to go back to the slide before. The EB5 policy manual, I think the most critical part from the June 2017 memo is what we kind of highlighted here in the bottom left, is that you do not need to keep your money at risk during the entirety of your I-829 adjudication. You only need to do it during your first 2 years of conditional green card status. That was something that was up in the air until 2017. even though the regulations were pretty clear that you only needed to do it for those first 2 years. But a lot of projects were structured conservatively so that the money would not be repaid until the 829 gets approved. That has required some modifications to PPMs, maybe loan agreements, things like that.
So basically, the redeployment could happen between those two milestones in red, showing here in this flow chart.
Exactly. So let's get into the let's get into the actual guidance that came out on last month. I use the term clarifies in quotations because I don't think it's that clear. And like I said at the beginning of this, USCIS considers this to be an interpretive rule, not a substantive rule that would require notice and comment. This is very much just how US immigration has acted historically. They set guidance, they can change guidance, and it's up to the regulated industry to do its best to comply with it, but if necessary, potentially challenge it. We're going to be talking about potential challenges later on. The notice that they put out on the 24th said this applies to all pending I-526s and 829s on or after the date of publication. And based on the question and answers that they posted on their website, I think it's pretty clear that they are intending to retroactively apply this new guidance. They say that it controls and supersedes any prior guidance, specifically the June 2017 policy guidance. And so now new commercial enterprises or their general partners or their managers are now looking at the different options and seeing, hey, have we been compliant? And if not, what needs to happen at this point? And so we're going to be talking just a little bit more about that. And I see we have some great questions already that have been asked in our Q&A. So please continue to send those in and we will be getting to those. Vivian, do you have any other comments about this slide?
I think I want to clarify that, some people mistake the redeployment rule with a different USCIS rule that's related to the integrity of the EB-5 program. In that rule, the USCIS say if the project didn't work out and the money has never been spent, the jobs were never created, the NCE can move the money to a different viable project and the investors can file a new 526 which can tag back to their original 526 if it was approved. So in that rule,
you're talking about the retention of the priority dates?
The retention of the priority date. So that rule is totally different from this redeployment rule. Under that circumstances, we are not even get to the point of discussing redeployment because the project has never created jobs with the original business plan. So for that rule, we're talking about how to avoid material change or how to file a new 526 and get back while keeping the old priority date of the first approved 526. So that's a total different scenario. That's a total different policies. So please do not mix the redeployment policy with that one.
Yeah, that's a good point. That's a good point. And that, if you do want to retain your priority date, that requires a new investment. Whereas here with redeployment, we're talking about what the NCE does with the original investment once it gets repaid from the job creating entity.
Right.
All right. So let's talk about the new guidance, what actually was indicated here. And so what they said here is that you need to deploy the capital and it must be in some sort of commercial activity. And one of the big things that they did is they deleted the reference to new issue municipal bonds, such as infrastructure spending. And, well, what does that mean? Does that mean that you can no longer purchase new issue municipal bonds in a redeployment option? The answer to that is no, you still can, because new issue municipal bonds are like a primary market. You're buying it directly from the person or the municipality that is issuing the bonds. What they are not allowing is purchase of financial instruments through like a brokerage on a secondary market. So for example, like REITs or mutual funds or other tradable securities. USCIS is saying, well, look, this is more of a financial activity as opposed to a commercial activity. And when we look at the EB-5 law and when we look at the regulations, really we should be talking about, making sure that this is related to the exchange of goods and services. And when you're just buying, securities from someone else, you're not really putting money into the economy for goods and services. You're just sort of trading ownership of these underlying securities. So that's one of the big changes there. Let's see here.
And it is no longer required that the redeployment goes to the same industry or the same business scope of the NCE. And the USCIS has said it will allow amendment to the NCE's operating or partnership agreement. So technically, the money can be redeployed in any commercial activity, regardless of the industry, that is consistent with the purpose of the NCE.
Yep.
Yeah, as long as it's commercial, like they don't allow you to make an investment, basically, to buy stocks or any short-term diversified investment.
And so, Vivian, does it need to be the same type of investment? Let's say you are providing a loan to the original JCE. Does USCIS prevent the NCE from further redeploying in, like, let's just say, an equity as opposed to a debt? Is there any restriction on that?
I don't think there's a restriction. I would imagine that the redeployment can be a direct investment instead of a loan. Even if the original project is a loan model, and I do believe USCIS will even allow some sort of pool of loans or pool of investment, because for most projects, each different investors will have their different investment terms. So it's very likely that when the redeployment happens, the NCE would not be able to redeploy the full amount of the original loan, because some people would want to back out. Some people would have already met their 2-year mark and are qualified to receive their investment back. So for the second or the redeployment, it's very likely that the amount will be a smaller amount compared to the original investment pool. So I would imagine, it should be an easy argument to make that, you can redeploy into a different investment model as long as it's commercial.
I would agree. Okay, let's continue. Let's talk about the redeployment after the job creation is satisfied. And this is really the key here, right? This is when the JCE has created the jobs, has repaid the money back to the NCE, what the NCE is allowed to do. And what they indicated here and what they clarified is that that deployment must be through the same NCE. It must be within the regional center's geographic area, but it does not need to be in a TEA. That further redeployment does not need to be in the TEA. And what they've also said is that, the money that is sitting in the NCE's bank account after it's been repaid, they say it must be deployed within a reasonable amount of time. And they've said that can be 12 months, although they'll look at the totality of the circumstances and potentially see if there were, longer circumstances would still make sense. And so, Vivian, we were kind of discussing this. What are some, totality of the circumstance factors that could impact whether within a reasonable amount of time would be beyond the 12 months?
I would say 12, the COVID-19 would be a very good reason to delay your investment. And, or for some regional centers in remote areas or rural areas, it's really hard to find a second qualifying project in a short period of time. And also, as I mentioned, like sometimes different investors may have different investment decisions, and the NCE may have, may need some time to find the best solution according to different needs of these investors. And sometimes they have to put them in different batch of investment or find a project that accepts installment instead of like one big one-time big investment. So those are also, those are all reasonable like reasons to explain that why you have to take more than 12 months to redeploy. And also, like this new rule just came out retroactively, and you have already put the money in some sort of investment that's no longer in compliance with the USCIS rule. I think in that situation, it's also reasonable to argue that, like with this new rule, we have to make a second decision, maybe retract our money that was redeployed already, and now we're looking for another qualifying project, just in order to meet your new rules. I think the biggest problem is with the retroactive application. If they don't clarify this, I think they're inviting litigation.
Yeah, that seems to be the consensus across the industry. I think the bigger question is are you people going to fight it now, or are they going to wait until there's actually been a denial, when there's actually been some sort of harm, and that would make the case ripe for some sort of judicial appeal. The other thing is that redeployment, this guidance has been around for 3 years now, but we really don't get questioned on it a lot by USCIS. I mean, Vivian, have you ever gotten an RFE that talks or questions about the redeployment?
No, we know that redeployment rule, the original rule, was issued in 2017. So in the past 3 years, we have never seen any RFE related to redeployment. Most 8 to 9 RFEs are like this boilerplate standard language asking for evidence to show sustainment of investment during the 2-year conditional green card period. And the evidence they're asking for are basically, very standard like tax K1 schedules for the petitioner's conditional permanent residency, and tax returns for the NCE. Usually, like, we only give them the K1 schedule to show sustainment, and the NCE or JCE's financials or expense documentation to show that the projects were completed or jobs were created. And all the applications were approved. I have never seen any RFE being issued on this redeployment issue. That's why I'm curious on how they're gonna request documents and what documents they could be asking, to show redeployment.
Right. Well, I think they would want to, if there was a loan, they'd want to see the loan agreement. They'd probably want to see bank statements, showing that the money has left in accordance with the loan agreement. Potentially the new redeployment bank statements showing that they've received the money and how they're going to be using the money. But I agree, they haven't really been asking for that yet. And there's another question that's sort of related to this that we have about folks with approved I-526s who are waiting for an interview at a U.S. consulate abroad for an immigrant visa. I mean, have you ever heard of a consular officer asking an investor about whether their funds have been redeployed?
No, never. Technically speaking, the consular officers are not going into details on the project. I don't think they have the knowledge on an EB-5 investment or like a project in general. Usually the standard question being asked at the consulate overseas are, you know, the names of the project, the name of your regional center, and where the project is, how did you find it, how much money you invested. I have never seen them asking, you know, like, can you show me documents to show, like, even like jobs are created? Because at the consular stage, you haven't got the conditional green card yet. Technically, your jobs do not need to be even created at that point. So I have never seen consular officer get into detail on job creation or you know, redeployment.
Right. I mean, and if you look at the field adjudicators manual, which is sort of the the Foreign Affairs Manual, which is what consular offices are governed by, there's not even a mention of redeployment in that when it comes to EB-5. So I don't even know if they're trained to be looking for this issue at all. But just in general, we haven't seen that come up at a consular interview. You know, one question that I keep on seeing here about regional center change, it keeps on coming up. So the guidance requires you to deploy it within, deploy it within the the regional center's geographic area. And excuse me, but if there is a termination of a regional center before you get your conditional green card status, whether that's through your fault or not, then USCIS will consider that to be a material change. And they will say, look, the underlying basis of your EB-5 application is no longer in existence. The regional center is no longer valid, and it's a material change. So your case is going to be denied, or we will revoke the approval of your I-526. And so that is something, not just in redeployment, but for all situations with EB-5, you know, making sure that you have a continuously valid regional center is absolutely key. It's absolutely key. Okay, so let's talk about, Vivian, if you don't mind, just sort of taking the lead here, talking about like what's next for an EB-5 investor. You know, what should they be doing at this time?
Well, the first suggestion I would give to EB-5 investors is you should at least keep yourself updated on 3 things. One, you should definitely keep updated with your immigration application status. For some people, I know that they don't even know what priority date is. They don't even know when their case was filed. This is definitely not smart to just leave your EB-5 application with your lawyers. You should definitely check with your lawyers periodically, and you know, find out when you can expect to when you can expect your priority date to become current, and when do you expect to get your conditional green card, when do you file your DS-260 or your adjustment of status, and which stage, as we show in the previous flow chart, the immigration milestones, which milestone are you? And also, when is your conditional green card due? So those timings are very important when you need to decide whether or not to redeploy your investment. And the second thing you want to be updated about is the status of your original EB-5 project. You should know if the construction, if your project is completed, if the project is operational, or you know, who is the contact person of your regional center. Some people don't even know who's the person responsible for the NC or the regional center. And also, you should find out if there's any negative media coverage about your project or your regional center. For example, if the project has filed for bankruptcy, you want to know that as soon as possible, and then discuss with your lawyer in terms of how this project changes impact your immigration application. And the third thing that you want to be familiar with is where your money is. Is your money still at the NCE's escrow account, or it has been released to the JCE? Has the money been spent on job creation? And when will the developer repay the loan? Or if the loan has already been repaid, when did it happen and how much loan has been repaid? So you should definitely know where your money is. And I know some people are like, some clients or investors like to, turn to their friends or even fellow investors for information or advice when it comes to redeployment. I really don't think that's a smart thing to do, because unless your friends are, like financial advisors or lawyers, but you should definitely not consult with your fellow investors on, redeployment advice, because as we mentioned before, each person has a different investment term. So it may be necessary for some investor to redeploy their investment so they're in compliance with the USCIS rules, but some investors may not even need to redeploy their money. And some people simply want to withdraw their investment and just give up their EB-5 application. So make sure you talk to your lawyers, make sure you talk to your investment advisors and corporate lawyers if necessary. If you want to understand the company documents and investment documents, talk to a corporate lawyer or securities lawyer, but definitely not consult with your fellow investors, because there's going to be a conflict of interest.
Yeah, I mean, what are your thoughts about interfiling? Would you interfile to demonstrate ongoing compliance, or would you advise investors to sort of wait to see if USCIS issues a request for evidence?
Well, at first glance, interfiling sounds like a way to go, but after a second thought, I was like, I couldn't figure out how you can interfile this. If you're still, like, if your 526 is pending, you don't need to interfile if the money has been redeployed, because at the 526 stage, there's no requirement on the sustainment yet. And after the 526 approval, you don't get a chance to interfile because there's no immigration application pending at that point. So the only situation you may want to discuss redeployment through interfiling is at the 829 stage. But as far as I know, there may be like very few people who have redeployed before they filed the 829. I would say just wait a few months and see how this is going, because we don't have enough information or guidance on how this new rule will be applicable to people who file their 829s. And as we said before, the USCIS rules are always evolving, and these are only interpretive rules. They're not like law. So it's always subject to changes. And I'm very curious on how they're gonna answer the retroactive application question in the next EB5 stakeholder meeting. I'm very curious on, how immigration is gonna, face the public on, why you're gonna apply this new rule retroactively. What happens to those people who redeployed with good faith in absence of this guidance? They redeploy the money to the best of their ability. Like, how would immigration deal with those people?
Right, absolutely. I mean, and that kind of gets to one of the questions that was asked is, if an EB5 investment was redeployed outside of the original regional center, what can be done? Will there be, and if this is retroactively applied, what can be done? Can you retrieve the EB5 investment back? Well, you have to look at the terms of the agreement that you signed, or that the NCE signed with the further redeployment option. Or let's say that you have obligations to provide a loan that you've signed, but now this new guidance has come out, and you don't want to redeploy the money in this area. Is the NCE going to be in default under this other loan agreement? So there are sort of these contractual issues that you have to deal with as well. It's you know, a lot easier said, oh yeah, we'll get the money back, than actually getting the money back. But I do think, you know, that USCIS will look at folks' good faith, or I hope that USCIS looks at investors and NCE's good faith attempts at complying with the law, and complying with what they say is you know, their current policy, and you know, hope that they don't deny these I-526s, or you know, will they initiate some sort of removal proceeding if they find out that, you know, an 829 gets denied because they find out that the money was redeployed outside of the geographic area? You know, these are unanswered questions. And I guess, you know, my response is you have to be ready to litigate in the event that a case gets denied because of this retroactive approval. It's just, you know, it violates fundamental fairness. So let's just go to what's next for regional centers and NCEs. Somewhat similar to, you know, what needs to be done for investors, understanding the redeployment requirements, understanding where your investors are in the EB-5 process. You know, one of the questions that we had here was, you know, is it a material change if there's been an I-526 approval, but there hasn't been a green card and the funds need to be redeployed? Well, yeah, the money can't sit with the NCE, so it does need to be redeployed. Is that considered a material change? Well, you have to look at what's in the business plan and what's in the operating agreement and the PPM. Do you have the authority to engage in these you know, deployment options? When I saw, you know, when this new guidance came out in 2017, and we were working with securities attorneys, you know, a lot of times the language that was provided was super broad and relatively vague, to give the NCE managers as much leeway and flexibility to do what they have to do to not only get the I-526 approval, but give them the flexibility to make a financial decision later on, because who knows how things are going to be going in 3, 5, 7 years from now when that redeployment must happen. And so, you know, that's one of the things that you're going to want to be looking at, is reviewing the offering documents. Obviously, you're going to need to be looking at redeployment options within the regional center's geographic area. If you have a small geographic area, it's probably a good idea to start looking into expanding your geographic area. You could do that with hypothetical projects. That doesn't need to be a real project. But you know, that will give you, you know, you file it now, you get it approved before any further deployment happens into that area, and that gives you some more flexibility on where you can have your further deployment. And then, you know, the big question now is, are you gonna wait for denials and challenge USCIS later on, or are you going to be looking to file some sort of injunction or a temporary restraining order, whatever the case may be, to stop it now? My thought is it may be a good idea right now to be patient with both the interfiling and with litigation. See exactly what happens once the comments come back. Potentially they'll modify what they have put out. And, you know, when you file lawsuits, you know, as we've seen in some of these other contexts, like the student visa ban, they may back down from their guidance. Or maybe a court will shoot it down and say, hey, this is inconsistent with the statute and the regulations, and your interpretation of the regulation doesn't deserve deference for X, Y, and Z. And there was a Supreme Court hearing, you know, about that last year, about, you know, what types of deference should be provided to a government agency who is interpreting their own regulation. And so I think there are, you know, challenges on the horizon, and that's something that every regional center should be thinking about as they go through you know, the process with their investors on getting their cases adjudicated. All right, so let's see here. That is sort of the end of our formal presentation. I am looking at some of the questions that have been asked in the Q&A. Let's see here.
There is a very good question that says, redeployment is to meet the continuous risk requirement. Why USCIS loops in all other grounds of 526 approval eligibility in the new rule, such as the same regional center? That's a very good question. And I have the same question. Why would they apply those 526 rules in the 829 stage? To me, the redeployment requirement should not exist in the first place, because the law does not have such a requirement. However, right, that's how the government, the administration, the USCIS interprets the law. So it's like they added on new requirements on that.
Yeah, I mean,
we don't know.
Right. And I guess, you know, just playing devil's advocate from the other point of view, and this is sort of related in that draft August 2015 memo, is, you know, well, when you look at the statute and regulations together, you have to show that the investor must show that they have invested the capital. Even at the I-829, you have to show that you invested the capital and that you sustained that action during your conditional green card status. And, you know, they are putting the at-risk, quote unquote, which is not included in the 829 regulations, within that sustainment requirement. And that's how they're sort of fitting it into the 829 adjudication. Again, this is something that I think is something to be challenged. All right, let's see.
And also, I got a second question. If I have a 526 approval, but have not yet received the green card and the funds need to be redeployed, is that a material change? The answer is no. Once the jobs have been created, you don't have the risk of having a material change in the project. Because we're only discussing material change at the with the initial business plan, the initial project.
Let's see. Okay, let's see here. Can investment funds be returned to the EB-5 investor during the pendency of the I-829? The answer is yes, as long as the 2 years of conditional green card status have passed prior to the funds being returned, even if the I-829 hasn't been approved. That's what was clarified in 2017. If the investment funds have been returned to the investor, can the NCE be dissolved? I mean, I guess if all of the 829s have been approved, that's a good question. I would hold off on dissolving an NCE until all of the I-829s are fully adjudicated. That would be my advice. Why give them any evidence or reason to deny the case? I wouldn't do that.
Can the investment funds be returned to EB5 investor while the 829 is pending? Yes. Once you have met the 2-year conditional green card period, the money can be returned to you without impacting your eligibility for the 829. So even if your 829 is still pending, but your money is already returned to you after the expiration date of your conditional green card, it's okay. Your 829 would still be approvable.
Okay. There's a couple questions here which talk about investment risk and stuff like that. I'm not feel qualified to answer those. You know, debt versus equity. I don't think there's a straightforward answer. I think you have to look at the details of the deal. Yeah, so, you know, it's 6:55 here in California. I think we're gonna sort of close up shop here. So if you guys have any other questions, feel free to ask them in the next 5 minutes. But here you guys have Vivian, you have my contact information. You guys can always go to our blog where we try to do our best to update on EB-5 and other immigration matters. You know, we try to do it on a weekly basis, if not a couple times every week, where you can learn about all of the fun and exciting changes that happen to immigration law. And so we thank you very much for you guys coming here, and we look forward to being able to assist in the future.
Thank you.